Why should someone establish a marital trust? Attorney Kellen Bryant explains, a marital trust should be established in the case of second or subsequent marriage, especially if you have children. The trust will address the most common concern in an estate, the surviving spouse and the rights of your children. Your surviving spouse cares deeply about what he or she is going to live on, especially if you own the majority of the family assets prior to marriage. The spouse with fewer assets and less income is going to be deeply concerned about what he or she is going to use to survive if you pass away as the primary earner. Your children and you are going to be concerned about your spouse leaving out your blood children from his or her will or trust when he or she dies. You don't want your surviving spouse essentially disinheriting your children. This can and does happen. If your assets are named jointly and you pass away, all the assets go to your surviving spouse. Your surviving spouse may have said when creating the estate plan that you were going to split everything equally amongst your children. However, once you are gone, your surviving spouse is the sole owner of all your assets, and outside of marital trust, he or she can decide to leave your children out of the estate distribution and leave only to his or her children. There is no legal restriction preventing your surviving spouse from disinheriting your children or requiring them to adhere to verbal commitments made during your lifetime. A marital trust is used to better define how you want to allocate your estate between your surviving spouse and your children. Put your mind at ease and make an appointment to meet with the Berg Bryant Elder Law Group in Jacksonville, Florida today.